My name is Peter Lukashevitz. I am the CEO of Gowling WLG Canada, and on behalf of my partners and everyone at the firm, I want to welcome you to the fourth of our Brexit seminars. Let me introduce my colleagues. To my immediate right is Mark Ledwell. Mark leads our financial institutions and services practice. Mark, previous to that, was our managing partner in London. And if you don't know Mark and you meet him for the first time, he will also very quickly tell you that he's from the Maritimes. Next to Mark is Kevin Sartorio. Kevin leads our intellectual property practice here in Toronto. Kevin specializes in intellectual property contentious work. Translated, that means litigation. Because the world changed again today, if you were to go onto our website and go to our home page, that's what you would see. And we put that there because that symbolizes our thinking when we decided 5 months ago as a 100-plus-year-old Canadian law firm to join with a 100-plus-year-old UK law firm to form the first co-led Canadian Anglo global law firm, Gowling WLG. We did it because we both felt that we needed to have a global presence in order to address the changes that are affecting our clients. And what occurred on Friday, June 24th, is an example of that kind of change, the rapidity of change, and the significance of the change. And so that's what we're going to talk about today, what happened on Friday, June 24th. Here's what we're going to cover. I'll do a little bit of background and context. I'm going to talk about how does the UK leave the EU. Really interesting process and an instructive process in terms of what we're going to experience over the next period of time. I'm also going to talk about what we at Gowling WLG believe to be the potential options for a post-Brexit UK-EU relationship. Mark is going to speak about what we believe Canadian businesses should focus on at this time. And he's also going to talk about CETA, something that we as a country and as a business community have not talked about a lot, something that we all need to learn about quickly and begin to think about as it is going to be an increasingly important agreement in the months ahead. Kevin is going to talk about Brexit's impact on intellectual property rights. And then I'll close it up and invite Kevin to say a few words. 37%. It's not a figure you see very often in the discourse that has followed the referendum result. What does it represent? It represents the number, the percentage of registered voters in the UK who decided this question. Slightly over 1/3 of UK registered voters decided the fate of the nation. And I put that up there because to me, it is hugely significant and explains much of the angst that we are reading about and hearing about in the days following the referendum. That number is derived from the fact that the UK voted 52% to leave the EU, but only 72% of the registered voters actually voted. So if you do the math, and I had my son check it to make sure it was correct, 37% of UK registered voters actually decided this question. In England, support for leaving was 53%. In Wales, it was 52%. But it was markedly different in Scotland. In Scotland, 62% of those voting, nearly 2/3 of voters voting, voted to remain. And so not surprisingly, on Friday after the referendum result was announced and on the weekend, the First Minister in Scotland was very quick to put on the table the prospect of a second referendum. And indeed, she traveled to Brussels that weekend to meet with the President of the European Council to put the Scottish case for consideration that Scotland, if it were to separate from the UK, might remain in the EU. Now, not surprisingly, since that initial foray, you've not heard much because of the uncertainty of the political situation in England. But nonetheless, this, in our estimation, is a real prospect. It's something that we will hear about frequently over the next couple of years. We still think that the ultimate issue of Scotland's separation from the United Kingdom will be very much driven by its ties to the English economy. But if the English economy continues to struggle as it has in the days post-Brexit, this could become a very significant issue in the next couple of years. Northern Ireland, a similar result. 56% of those voting voted to remain. What is unique about Northern Ireland is that it shares the only land border between the EU and the United Kingdom. In other words, between Northern Ireland and Ireland. The balance of the UK is separated by water from the EU. So you have this truly remarkable result that Northern Ireland might leave the EU and yet Ireland remain. And so not surprisingly, as in Scotland, very quickly Sinn Féin was out of the gate to say we have to have discussions about unification. Not surprisingly, that has been downplayed by the Unionists and by the government of Northern Ireland. It will continue to be an issue. There will be a real practical issue. Are they going to erect a border between Northern Ireland and Ireland? Two countries that have not had a border for decades where people are able to travel freely. Will there actually be a border erected? So that gives you a bit of the political context of how the vote was distributed and the percentage of voters voting for leave. So now, what's the current state of the political leadership in the UK? And I can tell you that this is the section of our seminar that has been changing virtually hourly, trying to keep up. I was saying to one of our guests that the first thing I do now is, when I come in, is check the Guardian and the Telegraph and the BBC to see, okay, what's happened overnight? And the other side benefit is I'm starting to learn how to do PowerPoint. So, the senior political leadership. As we all know, we will have a new Prime Minister as of this evening, Theresa May. And if you are a student of politics, but again, I think this has broader social implications, what will be unique about Prime Minister May is that she will have become Prime Minister based on an election by the Conservative caucus in the House of Commons. She's not been elected by the Conservative Party as leader. She's not been elected by the people. She's been elected by the caucus in a contest where the caucus thought it was voting for two candidates who would ultimately go to the Conservative Party membership to be elected leader. Pretty unique situation for a prime minister at this stage to have that limited base of authority. Labour, not to be outdone, is imploding. Jeremy Corbyn, who is the leader of the Labour Party, handsomely lost a vote of confidence, 172 to 40, from his own caucus. He had so little support in caucus that he can no longer form a shadow cabinet. Angela Eagle has announced that she is going to challenge his leadership. She has announced that she has more than 51 MPs in support. The requirement, according to the Labour Party constitution, is that you need support in order to be a candidate of 20% of the caucus, combined caucus in the House of Commons and in the European Parliament. She has it. Mr. Corbyn has been helped out by the Labour Party National Executive Committee, which yesterday announced that the leader doesn't need that level of support from the caucus in order to appear on the ballot. Quite, I would submit, an extraordinary result, undoubtedly driven by the fact that he hasn't got that support. So we face the prospect that Labour is now going to have a leadership contest. It will be decided at the Labour Party conference in September. Labour operates on a preferential ballot system, so if more candidates join the race, there will be a preferential ballot that will be distributed in advance of the conference, and party members will vote by preference. The party membership has expanded extraordinarily over the last 7 days. 100,000 people have joined the party. Its ranks are now 500,000, 500,000 party members. It is believed that most of those new joiners are supporters of Corbyn. And so you face the real prospect that Corbyn will be re-elected. He will not have the support of his caucus, and there will be no effective opposition after September in the House of Commons, something that the Prime Minister may well relish. The result of all of that is that we may see pressure in the fall on the Prime Minister to call an early election. The UK, like Canada, operates on a fixed election system. The next election is scheduled for 2020. However, there is provision in the legislation that with, not surprisingly, either a vote of non-confidence or, interestingly enough, a vote of 2/3 of the members of the House of Commons, an early election can be called. So that is a possibility. Not to be outdone, Nigel Farage resigned as well, and try as I might, I cannot figure out what the succession process is for the UKIP. I have tried, I have given up. I don't think the UKIP will be a significant force in the discussions that are going to ensue. Let me jump to now, how does the UK leave the EU? What's truly fascinating and what drives the uncertainty that we are all living in now is the UK cannot be forced out of the EU. It's quite remarkable if you step back and think about it. A country has said, we're leaving, and there's no ability in the balance of the organization to say, okay, here's the exit door. In fact, ironically, until about 5 or 10 years ago, there was no mechanism in the EU for a country to leave. It simply was never contemplated. There was nothing in the treaty. It was Britain who said, we need some exit mechanism for members of the EU. It was Britain that drove the creation of Article 50. And so Article 50 in the Treaty of Lisbon is the article that triggers the departure of a member. But it operates only when the member gives notice itself that it intends to depart. And the giving of that notice triggers a 2-year notice period. And at the end of that 2 years, absent any other agreement, the member state leaves. So you in fact now have 2 periods of time, the period before the Article 50 notice is given and the period after. What happens? Once the notice is given, the theory is that that 2-year period is used in order to negotiate the terms of withdrawal. That's the theory behind the 2-year notice provision. If an agreement is reached, it must be approved, not surprisingly, by the Parliament in the UK. It must be approved by the European Council. The European Council is the executive body of the EU. Its membership is comprised of the 27 heads of state of the EU. It must be approved by the EU Parliament. And, most interestingly, it must be approved by 20 EU countries representing 65% of the population of the EU. That, I would suggest, is no small feat to achieve in terms of the standard of approval that is required for the ratification of the withdrawal agreement. That's the process that has to be gone through to approve the terms of any withdrawal agreement. The other debate that is going on now is how is the Article 50 notice to be triggered? And the debate in a nutshell is this. There are some who argue that the Article 50 notice can be given by the Prime Minister. It is a prime ministerial prerogative. There are others that argue that because the Article 50 notice essentially triggers the cessation of a treaty, i.e. the treaty that defined the UK's entry into the EU, that only Parliament can give that notice. The view, our view, as a firm, having analyzed the situation, is that that latter is the correct interpretation. The government, some in government, have suggested otherwise. This remains to be played out. Litigation has started from those who take the view that this is a parliamentary prerogative in order to stop the Prime Minister from giving notice under Article 50. Why do I raise this? The House of Commons, as currently constituted, is overwhelmingly Remain. So you face the prospect of a Prime Minister having to go to the House for approval to give Article 50 notice in circumstances where MPs have declared their positions and they are overwhelmingly Remain. Will that change in the coming months? The Prime Minister, who was a Remain campaigner, has made clear repeatedly and is quoted again yesterday as saying Brexit means Brexit. Will that view be taken by all of her MPs? It remains to be seen. What are the options? The options after the giving of notice are that there's a negotiated withdrawal agreement, that there's an extension of the notice period. In other words, the parties can't agree on a withdrawal agreement within the 2-year period, and however, they can agree to extend the time. That's a possibility. The third is, there simply is no withdrawal agreement and there is no extension of time. And simply, the relationship falls away, the UK is out of the EU, and there is nothing in place to replace the membership of the UK in the EU. So we talked about a bit of timing, and let me talk now about what the post-Brexit relationship might look like. We think there are essentially 4 options. The first, and this is the most distant relationship, is a WTO or free trade model. In other words, the UK has a free trade relationship with the EU or individual countries, and the essence of a free trade agreement, as you'll hear from Mark with respect to CETA, is that there is no payment of tariffs on goods that move between the parties to the treaty, but there's still regulatory compliance. In other words, if goods move from the UK into the EU, they may move in tariff-free, but those goods have to comply with all EU regulations. It's the most distant relationship, if you like. Another possibility is a customs union. And we put this forward because currently Turkey has this relationship with the EU. It again provides for tariff-free access. It goes further in that Turkey and the EU have agreed to treat themselves as one entity for the purposes of dealing with goods from outside the EU and Turkey. So in other words, they take the same step in terms of levying tariffs on goods outside of the EU and Turkey. There are two big problems with this relationship. One is it doesn't apply to services. And services are a key component of the UK economy, particularly insofar as the relationship between the UK and the EU. Secondly, this relationship was offered to Turkey because Turkey is on its way in to the EU. It is, in our view, very doubtful that the EU would offer this relationship to a country that is on its way out of the EU. The next option is the European Free Trade Association. This is an association of 4 countries: Iceland, Liechtenstein, Norway, and Switzerland. They in fact they have their own arrangement amongst themselves. Within EFTA, there are 2 relationships with the EU. The Swiss, and I hope I don't offend anybody, my grandmother was Swiss, so I'll put that on the table, but the Swiss, being the Swiss, have gone it alone and negotiated a series of bilateral agreements with the EU. Now, tiny little Switzerland, with its economy, has 120 individual agreements with the EU. Imagine trying to apply that model to the UK. I suggest you could probably multiply that by 10 or 20 in terms of the number of agreements that you would have to negotiate in order to address the issues in those 2 large economies. In our view, it is simply impractical to contemplate that being done in a decade, much less 2 years. The other option is that Iceland, Liechtenstein, and Norway together are members of something called the European Economic Area Agreement, or EEA. And the EEA has an agreement with the EU. And in the popular press, you'll often hear this referred to as the Norway option. Not sure how Norway got top billing. Seems Iceland's better at football than Norway, but nonetheless, it's Norway. So the Norway option is that you have this agreement with the EU that essentially allows for freedom of movement of goods. What's the problem? The problem is that as part of this arrangement, the EEA accepts the 4 freedoms: movement of people, movement of capital, movement of goods, movement of services. That key issue in the referendum was the first of the 4 freedoms. Mark will talk about them, the movement of people. It is hard to see how this could be a potential option, given the requirement of the agreement that the parties to the agreement accept the free movement of people. It's a possibility. We think it is dubious. So those are the 4 options, and now I'm going to turn it over to Mark to talk about what business should focus on in the coming months. Mark.
Thank you, Peter, and good morning, everyone. I think the last 3 weeks have been a great time for the media, all the drama and uncertainty. But as you know, business and markets thrive in certainty. They do best in certainty, and we've had anything but certainty over the past 3 weeks since the surprise decision on June 23rd. And that gives rise to the question, I think, what should business focus on during this period of uncertainty? As someone has said, is it the new normal? We've outlined 4 considerations that business should look at in light of the decisions that have been taken. The decision, I think most will agree, caught us and caught markets by surprise. In hindsight, there was little planning done for the leave decision, and there seems to have been a contingency plan developed, thankfully, behind the scenes at the Bank of England. But other than that, there seems to have been no serious planning done for a leave decision. Most business leaders that we've consulted with admit that they did not see the leave decision coming, and accordingly, they didn't do a whole lot of planning for it. So these are 4 things that we've been discussing, 4 considerations that we've been discussing with business leaders since the decision was taken. There's a strong view among the people that we speak with that increasingly the Brexit decision isn't going to go away, that it's here to stay. The new Prime Minister, as Peter has mentioned, and others will say, has declared that Brexit is Brexit. Last week, the former Foreign Secretary, Lord Hague, was speaking here in Toronto, and I think he counseled his audience that the idea of a do-over is probably not on, and that we should get ready for Britain charting a new course in its economy and in its politics. That said, as Peter has mentioned, there still are some parliamentary issues that will get worked out over the next 1, 2, 3, 4 years, we don't know. So let's start with of the first of these 4, decision making. The biggest decision we hear about from our business clients is, do we hold and take a wait and see approach in our decisions, or do we carry on with our plan? And in the face of the uncertainty that we've now experienced over the past 3 weeks, many businesses that we're dealing with are in holding pattern. Our colleagues in the UK have told us that a lot of business transactions that were on the planning to close in June, July, August have been pushed off into the fall, and they've been pushed off into the fall waiting to see how things will evolve over the summer, and things clearly are evolving. They've also said that the biggest pause push is coming from business in other parts of Europe, whereas American clients and Asian clients, clients from the Middle East, view the shakeup around Brexit as probably more of a business opportunity, whereas the FX issues and the exchange issues around currency, the sterling and euro are complicating business planning and thinking in transactions as between European countries. But political events over the past 3 weeks suggest that we have to really expect the unexpected, and it's very difficult to plan in this type of environment. We're not here to judge the actions that have been taken by the various political leaders over the past 3 weeks, but clearly what's taken place on the political side of things has had a deep impact in business decision-making and in the markets. Fortunately, the governor of the Bank of England, a Canadian who will be here, we were told later this week, speaking here in Toronto, has been a stabilizing voice in the post-Brexit calamity, and we think his comments should be carefully considered. As most of you, or some of you will know, the bank's Monetary Policy Committee is set to meet tomorrow, and the press conference that will follow will be carefully watched, I think, by business observers around the world. A second consideration for business in the post-Brexit period are the immediate economic impacts. And we've outlined what some of them are here. We've already seen a weakened pound. The question really is, how long will that last? The pound dropped to its lowest level against the US dollar over a 31-year period 2 weeks ago. Since then, it's climbed back, and it seems that every time there's a decision taken, the pound will either improve or fall. So yesterday, over the last few days, with the announcement of a new prime minister, it started to climb. What will happen tomorrow? We're expecting that Carney will comment or introduce a rate drop. That could cause the pound to fall. The last time he spoke, the pound dropped. Within 30 minutes of him speaking, the pound dropped and the markets improved. So there's a lot in play. A second factor is this slowdown in the UK economy, and some are predicting a recession later this year and early next year. Quite frankly, Carney warned of that. He was accused of fear-mongering. He said it was his job to put facts on the table, and so far what he said is playing out and is accurate. Thirdly, the governor has indicated or hinted at an interest rate. His press conference a few weeks ago following the Boris Johnson departure was, I think, truly remarkable. Most observers didn't see a bank governor that active and engaged. It was almost like I hate to say this, but like a Donald Trump press conference, but he was answering questions and I think clearly trying to stabilize what had become an unstable situation within the UK at that time. And finally, there's uncertainty in the near and midterm, and clearly there's been a general weakening of markets. You've all read about and experienced trillions of dollars being wiped out of the markets following the June 23rd decision, and since then it's been creeping back up. But commodities are affected, interest rates are affected, people's savings have been affected, people's pensions have been affected, the equity markets are sluggish, the real estate situation in the UK is depressed, real estate funds are closed, so there's been all kinds of activity following the June 23rd decision. On the other hand, we're picking up signals this week and last that governments are more engaged in thinking about stimulus activity. The idea of austerity is not at the top of the list these days, and we're hearing that from the UK. We're hearing that a new chancellor, who we expect will be named tomorrow in the UK, will not be an austerity style chancellor. We're hearing that the Germans are thinking that way as well. So it could be that the approach that Justin Trudeau has taken to stimulus and infrastructure is being looked at carefully in many European countries, because clearly it's found favor and success in this part of the world. Some of the specific considerations a business organization should think about and consider in this period of uncertainty are discussed in this slide. There are 6 various considerations here, but I'd like to focus on perhaps 2 of them. The third one is worth considering, and that is, are there pending transactions that should be or need to be reassessed in light of changed circumstances? In our business, sometimes we refer to this as a MAC, material adverse change in circumstances, and many contracts have MAC clauses. Some people have questioned whether there's been a force majeure as a result of this decision, but when you're in a contract that's governed by English law, or the law of England and Wales, that has an overlay of European law, this uncertainty gives rise to an opportunity to either renegotiate a contract, get out of a contract, delay a contract. And in our practice in the UK, we've seen all kinds of situations, even in my own practice, where clients have come and said, I'm not comfortable going ahead right now, find a way to stop this. And these are the types of clauses that we look to when we're about to do that. The other one to consider is the 6th, and that is your business positioned to capitalize on new opportunities? that may present themselves. And for Canadians and Canadian business, an additional factor here is the status of the free trade agreement with the EU that we'll talk about in more detail later. A third consideration for business is the anticipated change in the legal relationship between Canada and the EU, but also between Canada and the UK, and Canada and any country that may leave the UK and join the EU, for example, Scotland or Northern Ireland. Today, we really don't know the extent of what these changes will be, but it is probable that there will be change. What is striking is that the political leaders that Peter has just spoken about, they probably don't know what those changes will be either. So they don't know much more than we do. And we all are getting ready for a process and period of change of law. So there's apprehension across England, across Europe, and with business that does engage with the UK or across the EU. And but it's important to remember that as of today, there has been no change in law. There has been no amendments to laws. There have been changed circumstances, but the existing legal arrangements have not changed. The UK joined the common market, as you know, in 1973, almost 43 years ago. And the common market is built on 4 fundamental freedoms. They involve the movement of goods, the movement of services, I should say the free movement of goods and the free movement of services, the free movement of capital, and the free movement of people. These freedoms are reflected in the various UK laws, regulations, directives. You probably heard about UK directives, certainly living there I have, and policies, all of which are designed to harmonize the legal framework between the various member countries of the EU, including the UK. Of special importance in the UK is the free movement of services. Why? Because so many service people and providers come to the UK to live, to work, to do business. There are approximately 3 million EU citizens who carry EU passports living in the UK today. And they're concerned about their own futures, but their employers are concerned about their futures as well, particularly financial institutions who will tell you that they have to have this EU passport in order to continue to thrive, in order to maintain the City of London's status as the financial hub for both Europe and for the world. It's a very important issue, and it's a big part of the UK's GDP. So, as a consequence of Brexit, the law and policy that provides for these freedom of movements in these areas will change. It's expected to change. If we follow the Denmark model, as Peter has just described it, that could result in no change. If we revert to the so-called WTO model, the old model, there will be all kinds of changes. And people are thinking about those things now and trying to contend with what the fallout may be. A key question for business in all of this, really, is how will my business be affected by less than full access to a common market? And we lived through that in Canada with NAFTA. We've experienced both sides, what it was like before and after the NAFTA. Here, there's been considerable discussion, as I said, about the EU passport and its impact on key employees and how important it is for banks and financial institutions, but it also has impacts in other areas. For example, in supply chains, a lot of businesses have built a supply chain around a common market. I'm thinking particularly of the automotive sector, the pharma sector, the aerospace sector, the defense sector, anything that involves manufacturing. There's a parts going back and forth, just like the manufacture of automotive equipment between Canada, the United States, and Mexico. And this just isn't a concern for UK business. The German Chancellor has been reminded that there are 800,000 cars sold annually, manufactured in Germany and the UK. And I'm told that she's had all kinds of representations from German manufacturing leaders about what she's going to do to keep the borders open between Germany and her manufacturers and the 64 million consumers who live in the UK. So it cuts both ways. The final point, I think, for business is how will Brexit impact the harmonization of EU laws and create a dual regulatory environment this between the UK and EU member countries. And we've outlined 8 sectors or areas where we'll be watching to see what these changes will be. First of all, in life sciences, Kevin will speak in a moment about intellectual property, but the harmonization of IP and patent laws is extremely important to life sciences companies across Europe. Data protection, UK, if you live in the UK, work there, you're subjected to the overlay of EU data protection laws. What will happen to those? Antitrust and competition, there's a lot of angst about state aid. We're involved in several energy projects in the UK that involve allegations of state aid, and state aid has been the purview of Brussels, much to the chagrin of many people, including political leaders in the UK. Sector regulations. You've all heard about the fishery and the unique rules that come out of Brussels around the fishery. And of course, you probably heard about the bananas and the EU directives that govern and speak to the shape of the banana and what the shape allowances are if a banana is going to be allowed to be sold in a store anywhere in the EU. That was always jumped on by the Leave campaigners. Employment. Having been an employer in the UK, I can say to you that the employment laws were not like anything I'd ever seen before, and a lot of them had to do with the convergence of UK law and the EU directives. Consumer protection and product safety, commercial agents protection, and late payment protection. All of these things have been the subject of a harmonization process, and people are really scratching their heads about where would you start if you were trying to untangle. What could all of this look like? So it's a bit mind-boggling. What does Brexit mean for the CETA? And if uncertainty around Brexit isn't enough, I'm afraid to say that there's an added complication for Canadians around the future of the CETA. Of course, everyone wants it to happen. Everyone wants it to be ratified. It couldn't be ratified soon enough. We wish it was ratified before June 23rd. It wasn't. So the question, I think, going through many minds is, how will the CETA be affected? Will it be affected by Brexit? These negotiations commenced in 2009, and the point has been made that it's taken 7 years to get us where we are today. These are not easy agreements to work with. This agreement has been described by the European Trade Commissioner, by our Trade Minister, Chrystia Freeland, and by others as the most modern trade agreement in the world. It's something to be proud of. Can we hang on to it? So there is a 3-step ratification process involving the European Council, the European Parliament. I know you're thinking perhaps that's a lot of bureaucracy, and EU member state parliaments. And there is uncertainty about how all this will work. Will it be business as usual? And right now, there's a bit of a dispute brewing between German Chancellor Merkel and the EU Commission President, Mr. Juncker. He says that the EU Commission executive has the authority to ratify this agreement, and they'll do so this fall. She says they don't. Her view is that each European country, each member state parliament needs to approve it and needs to be involved in the ratification process. The process of unwinding the UK from the EU may take years. So the question is, what will happen to the CETA over that time period? And we've outlined here 3 different scenarios or potential options to consider. The first one is that the UK is cut out of this agreement because today the UK is a clearly part of the EU, and it's by virtue of being part of the EU, it's part of this agreement. So if it's cut out, Canada and the UK conceivably could negotiate our own agreement. And there are people thinking about that as we speak. A second option is that the UK joins the European Association, the so-called Denmark model, and adopts the EU single market, including that would include the CETA. So you become an association member rather than an EU country member, and because the EU has the CETA, then by virtue of that you adopt it. And the third is a bilateral UK-EU agreement, a so-called bespoke agreement between the UK and the EU that is signed directly between those 2 parties, and that could include rights under the CETA. People I've spoken to have said, how long will this take? Because it took 7 years to get Canada to where it is today with the European Union. And within that, there were all kinds of political forces among the 28 EU member countries that held things up around things like cheese and supply management, and aerospace parts, and defense spending, and that sort of thing. So how do you pull all this together? And it's a real challenge, and it's going to require a lot of leadership. Why is the CETA or CETA important to Canada and Canadian business? And quite frankly, I didn't really get this until I started to review this material for this session. But really, the EU economy, as it's presently constituted, if you look at 2013 data, is roughly 8.5 times the size of Canada's economy. It's a $18 trillion economy, and Canada today is a $1.9 trillion economy. So it's the world's largest economic unit, larger than China, larger than the United States. It's our 2nd largest trading area, and we import a lot of their goods. They import a lot of our goods. So it's important to business. And what happens with the trade agreements between the EU and Canada, therefore, are important. They have to be carefully considered. Let's look at impacts. The impact of a ratified CETA today, and it's not ratified today, so we're still in a bit of limbo. These impacts are sweeping, and we've considered them in 3 areas. In goods, in the area of services, and the area of investment. So briefly with respect to goods, if CETA were ratified today, almost all of our goods would pass duty-free in the EU, except for some of our agricultural products. And I was speaking with a Canadian manufacturer on Monday in Nova Scotia, who's in the agriculture business. He was telling me that in some countries he faces tariffs in the range of between 30 and 50% to get his products into the EU, some certain EU countries. And he's waiting, he's hoping, he's pushing, he's lobbying for this agreement to be completed. Another area of impact are services. Approximately 70% of our GDP is comprised of services. And the trade agreement with the EU, with the CETA, is important because it provides and reduces barriers around the transfer and delivery of services. So it will reduce residency requirements, and it will make, I know when I went to work there, it took me 6 or 7 months to get myself official and get a permit to work there. And a lot of those barriers would come down. And the third area of impact is investment. And this is an area where we see a lot of discussion taking place today in boardrooms around Canada. Canadian banks, Canadian pension funds, Canadian private equity funds are all concerned about the free movement of capital from Canada inbound into the EU, and conversely, the flow of capital from the EU countries to Canada. But as you know, a lot of Canadian pension funds are heavily invested in the UK and increasingly across the EU. The status of this trade agreement is important to them. Canadian manufacturing concerns are important. The Canadian agricultural community is concerned about this as well. So I'm of the view, I think we're of the view, that with respect to the status of CETA, we know that Minister Freeland and Prime Minister are out there pushing to get it done. We sense that the German Chancellor is going to slow things down. European Trade Commissioner, European President, EU Commission President, Juncker have all been saying, we're pushing on, we'll get this done, but it's just too soon to say in our view, and unfortunately, we come back to that word uncertainty. There is uncertainty about when the CETA will be ratified. So thank you for listening to this. It's a complicated subject, and Kevin, I invite you next to come and speak about IP.
Thanks, Mark. I've been asked to comment on what Brexit means for intellectual property, and I am mindful of the time, so I will keep my presentation at a high level and moving along, but I'm happy to speak at a granular level with anyone on a one-by-one basis for sure. I'll be covering two topics. First, I'll be talking about obtaining and enforcing IP rights. Patents, trademarks, and copyrights being the three main intellectual property rights. And then I'll touch on contracts that deal with IP rights and what you should be thinking about. But let's start by distinguishing a patent from a trademark from a copyright so you know what I'm talking about. A patent is the exclusive right to make, use, or sell an invention. An invention is something useful, it has utility, it works, it accomplishes something, and it can be a device like a better mousetrap, or it can be a drug. Patents are granted for things that are new and non-obvious, but it doesn't have to be entirely new. You can get a patent for an invention that improves upon an existing technology, but a patent is for something that accomplishes an end objective. And that's different than a trademark. A trademark is something that identifies the source of a good or service to consume. So, Peter, if you'll hold up your coffee there, that's going to be recognizable as a Starbucks coffee, and that mark and symbol distinguishes that from a Tim Hortons coffee that some of you may have had this morning as well. So trademarks are gained in association with particular goods or services, or in some countries, classes of goods and services. And what you get from a trademark is the right to prevent others from using a confusingly similar mark that might confuse consumers as to who stands behind the good or service. And a copyright is neither a patent or a trademark. A copyright is something that pertains to the protection of original music or literary, artistic, dramatic works, all of which are probably on some of those phones that you're holding up right now. And it pertains to other things like source code, sound recordings, performers, performances, but generally speaking, what a copyright owner gets is the right to control who reproduces, performs, or publishes all or a substantial part of their work. So these are the three main types of IP rights. And what I want to talk about now is the different routes you can go about taking to get national rights in a country. And there's really three of them. One way is to just go country by country and apply in each country's intellectual property office and seek the right that will be enforced in that country. You get a registration from the office, you go to the courts of that country if you have to enforce it. Problem is, what if you want to have the right registered in another country? Well, if you're going directly at each time, you gotta repeat the process over and over and over again, and that can get pretty expensive if you're interested in seeking protection in more than one country. Naturally, that's what everyone wants. They want to register their rights as broadly as possible. So there are international treaties and conventions that have been ratified that work in different ways, but generally what they do is they allow you to start with a single application for the IP right and use it to more efficiently obtain registrations in other countries of interest who participate in the treaty or the convention. Ultimately, at the end of the day, you still get a series of registrations in countries and you have to go to the courts of each country to enforce them, but it's more efficient than just doing it one by one. The most efficient way is something that's called a unitary system. And in a unitary system, you apply a single time and you get a registration for an IP right that is enforceable, sometimes to a unitary court, across all member states. And this sort of system exists in the EU for trademarks. It was proposed for, or it is proposed, for patents. And so I'm going to focus on number 3, but I'm just going to go over these quickly again in detail and help you understand why the first 2 are not effective. So again, country by country, if you have or know somebody who has obtained a IP right in the UK, directly in the UK office, it's not going to be affected by Brexit. The UK is still going to enforce that IP right within the UK. Same thing if you've obtained protection in the UK through an international treaty. These are independent of the EU, and these streamlining treaties exist all over the place. For patents, there's something called the Patent Cooperation Treaty and the European Patent Convention. For trademarks, there's the Madrid Protocol. These are not affected by Brexit directly. The rights that have been recognized in the UK Patent or Trademark Office, for example, under these protocols and conventions are still going to be recognized in the UK. And all of the treaties work in a different way at a technical level, but all of them allow you to designate multiple countries based on a single application. For copyright, it's even easier or less affected. Treaties like Berne, for example, they basically provide, and they've been long negotiated, that copyright arises automatically throughout essentially all countries of the world, with very limited exceptions, without even the need to seek a registration. So copyright is not really affected at all. It's the third system, unfortunately the most efficient system, that is affected by Brexit. These are the ones where you apply one time and you get a registration that's enforceable through all member states. It doesn't exist for copyrights. It does exist for trademarks. It's called the European Union trademark, and it's proposed as a unitary patent system in the EU. So looking at trademarks, direct filing is not affected, Madrid Protocol is not affected, but the European Union trademark is affected. And until Brexit is sorted out, if you have a European Union trademark, it's still going to be valid and enforceable throughout the EU, including the UK. The problem is, once Brexit is completed, however it completes, and the UK ceases to be a member of the EU, we don't know what's going to happen in the UK with respect to the EU trademark. What happens next? It's possible that there will be a mechanism adopted or negotiated or put in place that will simply, in effect, say, if you have a European Union trademark, it's going to be recognized in the UK as a UK registration. That would be great. Unfortunately, it's also possible that won't happen, and if you want protection in the UK, you may have to use one of those treaties or file in the UK directly. And you can consult with your trademark advisor whether you should be filing now or whether you can wait and see what happens. Similarly, for patents, direct filing is not affected really. Neither are filings that are recognized in the UK according to international treaties such as the Patent Cooperation Treaty or the European Patent Convention. It's the unified patent system, including a unified patent court, that is affected, unfortunately. And unfortunately, we don't really know what's going to happen. It's supposed to be in place by about 2017. Brexit's going to delay it, perhaps for 2 years. And until negotiations are completed, as Peter and Mark have been talking about, we don't really know the extent to which the UK is going to participate in that system, or the court, if at all. And as I mentioned, copyright is not going to be affected directly. It's possible that EU may issue directives for their own application of local copyright laws that the UK will choose to endorse or not endorse, but that's fairly modest. So those are my comments about obtaining and enforcing IP rights. But of course, you do more than apply and enforce. You want to make money off of IP rights. And you do that through agreements like licenses and joint ventures. But IP applies to many types of agreements as well, settlement agreements, coexistence agreements, and other things. And of course, as Mark was talking about, for existing contracts, if they cover the EU as a defined territory, you should be reviewing them and considering how they may be affected. What are the parties' expectations? Do terms need to be reopened? How should you position yourself for a contractual dispute as to the interpretation of what Brexit does or does not do? And for future contracts, you should definitely draft them to accommodate extraction of the UK and unfortunately maybe other countries in the future without having a need to reopen the terms. Of course, this may be problematic for existing agreements. So those are my comments on IP. I thank you for your attention, and I turn you back over to Peter.
Thanks, Kevin. Thanks, Mark. So let me wrap this up very quickly by leaving you with two thoughts. One is just speak to you as a fellow business person. We all, as Canadians, have a stake in what's happening with our friends in the United Kingdom and in the EU. We hope that we've shown you through this presentation how we, as Canadians, citizens and business people, have an interest in what is happening. And I think we have a role to play in the discussions that are going to unfold in the coming months. And I can tell you, certainly as the CEO of Gallink WLG, we intend to be at the forefront of those discussions. Second takeaway from this is, if you are doing business in the UK or in the EU, or if you are contemplating doing business, take the opportunity now to step back and think about your business and think about the issues that may impact your business given the events in the UK and in the EU. How can we help? You can contact our folks. You can also go to our webpage. We have a webpage, Brexit Untangled. It's being updated daily. You'll find there articles of interest based on sector, based on practice. So go there periodically and get updated on what's happening.